Welcome video watchers. All right, I'll start it that way.
You're gonna get a million hits.
And they get a million hits. All right, Ming, you're right on time. We're just getting started. All right, and I know the weather is less than conducive
it's
to being here.
traffic.
All right, so guys, here's the agenda. I'm going to give a quick summary of what we've covered. I'm going to say what we're covering today. Our guest speaker, because he's being very kind, because he's a busy guy, but he's one of the most talented defense attorneys around. He is going to be here anywhere from 5:45 to 6 to 6:15, depending on traffic. So we got to be nimble here. We'll take a short break, bathroom break, right when he comes in, and then we'll get started within 5 minutes after he arrives. He will speak for an hour, hour and a half. We'll take a break, and then we'll finish up from there. So, a little overview. All right, so we had the general introduction about our professional duty to the system. We have sources of professional regulation found in all different places, including state regulation, federal regulation, Circular 230. Chapter 2 begins tax preparation and advice. And, all right, how are you? We got the videotape?
Yes.
All right. And we have the transactional planning and advice in chapter 3, where we talked about things that will crop up. We'll get more elaboration today from Tim Say about client conflicts. You'll see that it's one of the key or chief reasons that there's malpractice suits. And we know, because Peter's practice, that was one of the essential, not only, one of the essential elements in malpractice cases. You were the guy who shouted it last class. Okay, I'm glad we're prepping before. You recall, Nick, what I'm talking about? Essential element for a malpractice case, beginning with the letter D.
Damages.
Damages. Damages, right? You know, it's not good enough, right? Just that you have a bad accountant, bad attorney. You got to prove damages, right? Okay, so you'll hear more about that today. All right. So the fact you have a conflict doesn't mean you'll necessarily get sued, but the client can prove that they were damaged because you put them in a bad position. You have conflicts between clients, your own clients, or conflicts you may have with your own clients. We talked about opinion letters and written advice. Chapter 4, we spent a class or two talking about the importance of client confidentiality, why that's one of the central tenets of our profession, being accountants, and also about the work product doctrine and how that is an entirely different set of rules, and that is far more, less defined, right? Far less defined than the confidentiality. You can waive either or both privileges. The fact you waive one privilege doesn't necessarily mean that you waive the other privilege. And we talked about the general rule, and we talked about the fact that some of these doctrines, right, that there could be exceptions, right? Someone's about to commit a crime, you don't have to, come on in, Mike. You don't have to worry about the privilege. And then we began Chapter 5, last class, about the unauthorized practice of law, and we looked at the accountant who had done tax work for a 1950-something case. And in that case, the court ruled that his actions constituted the unauthorized practice of law. We said in the year 2019, that case, its outcome was suspect, but that you have to be careful as accountants not to practice law, or at least certain facets of law. All right? We're going to go more into that in depth today. And we're going to see what we could do in terms of Chapter 5, what can be done with respect to multi-jurisdictional practice, and what you can do in terms of advertising. What are the bounds of permissible advertising for accountants, and what is the permissible bounds of advertising for lawyers? Saturday, just to give a heads up in case anyone leaves early, just keep in mind that in an ideal world, we will finish chapter 6 on Saturday. And if we do, we'll have mission accomplished because we will have completed the entirety of the textbook, all right? Also on Saturday, if you could kindly bring your 3-page paper directly to class, that would be terrific. If you haven't secured your identification number from Rita, please do so. I know Kevin is having some problem. Everyone else has a number? Marie, did you reach out to Rita?
Yeah, I have the number. My question is, should I come to this class next time? Saturday, or?
You don't need to. Send me an email, we'll figure something out.
Okay.
Marie is taking another class simultaneous, which is very important for him to get his feet into the program. So it's a good thing for him to not be here on Saturday.
Okay, so we get a number, then we still bring the paper, or?
Yeah, because you bring the paper with the number. Okay?
So it should not say the essay number, it should say the number that Rita gave to us.
Yes.
Okay.
In other words, to, like theory, like a memo,
Yeah.
to say Professor J sold from the number.
Okay.
And then you can say RE, essay, whatever,
Yeah.
or you can use something more. I would probably put whatever the RE is plus in parentheses the essay number. That can't hurt. All right? Everyone's got the
I
thing?
sent
You okay?
out an email, but so far haven't got back
From Rita?
from me.
Tomorrow, if you send her another reminder,
Okay.
then just copy me on that and I'll follow up with Rita. Kevin's in your boat, but last I checked, there's, I think 11 or 12 of you already have.
Yeah, I don't have many.
Maybe.
Did you ask Rita?
That's okay.
You gotta do it, okay?
Maybe it's late for me. I
All right.
sent out this afternoon.
All right, send it out with me copied, and I will pursue it and just make sure that's all fully into place tomorrow. All right, other logistical questions? So, B.
So because it's a memo, should we include a lot of footnotes? I mean, memos don't usually have footnotes.
You don't need it, but once in a while there's something ancillary that you think, hey, this should be in a footnote.
Okay.
Right? I can't. Some
Right.
people will find it useful. Some people won't. I know when I write some kind of writings like law reviews, there's a lot of, but in others there aren't. So.
Can we
really.
put the footnotes on the fourth page? On the fourth page, the last page, because it's not enough for the
And you can
first
put
3 pages.
whatever you want to do, but just keep it on 3 pages. Don't go on the 4th page. There should be no 4th page.
I mean, the note, footnotes.
Footnotes you can, and
Still
they can be
includes-
10 point if you want, 10-point font. Okay, the footnotes. Some of you before class or someone said, what was the upshot? I was the expert witness, and last time I held you guys and said that they were out for 5 days. So on Monday at 2:59 p.m., I get a text. The verdict is in on my month-long federal Hobbs trial. This is from Isaac Wright, who I told you, if you look him up on Wikipedia, quite a fascinating story. And in all caps, guys, not guilty on all counts.
And you testified for the defense.
Yeah, for the defense. So I just said, so happy for you and your client. And Isaac Wright wrote back, thank you for your priceless participation. So
You never got the money anyway.
there was never money to get. And he's serving time, so some people said, do you really feel good letting this guy go because he did commit a crime? I said, it's not a question, he did commit a crime, should he serve 10 years or 25 years? And I just thought 10 years is enough of a
So
person's life.
ultimately, it becomes a state crime.
It's now a state crime, it's not, federal crime. And that was the only distinction, and believe it or not, if you're gonna rob someone, everyone hear me? Do not rob a business. Rob someone personally. So if you're desperate for money, you got my message? All right, Kevin, you're on to that, right? All right, so everyone knows if you got to commit a crime, know where you're going to steal from, guys. And if you've seen the movie My Cousin Vinny, just be careful. All right. I know if I shut a door, then 3 people will, but if it comes up, I will shut the door and put a magic marker in. So I believe we left off on page 245, right, guys?
Yes.
So let's go through some of this in terms of we have a case, it's a U.S. Supreme Court case, and Viva pointed out, and she may be onto something, and Viva has one of these cases that you can get it's not this case, but I wonder, Viva, if all U.S. Supreme Court cases are recorded. They may be.
This is the new website I just checked it because I'm always checking the summary of the cases. So today morning only I found this case.
Okay.
I don't
Did
know.
you? But you know what? Spurry v. Florida is a 1963 case, so that's 55 some odd years old, and it may not be. The case you looked at is much newer. This deals with the U.S. Patent Office, okay? And the question is, you have someone who's practicing in Florida, and they're strictly doing patents. Now, my knowledge and your knowledge of patents is probably pretty thin, or at least I'll speak for myself. My knowledge of patents is pretty thin, but when we talked just a moment before about the case I was an expert witness on, regarding that case, there was an issue of federal versus state law. Well, similarly, in the case of the patents are federal, right? Everyone agree? You can't get a state of New Jersey patent. It's only federal. And the question is, in this case, can someone who is a lawyer, opens shop in Florida, and all this person does, their entire practice is patent law, is that the unauthorized practice of law in Florida? And bear in mind, why do states have these laws? In theory, not in theory, the reality is every state has its unique set of laws, right? And to protect the public, remember, that's the big thing about being a profession, self-policing. The profession is supposed to protect members of the public by self-policing and getting rid of bad apples. Agreed? So, most states are very protective of their turf. They don't want lawyers from outside the state stealing business, or let's put it this way, they would never frame it that way. They would say, look, we're here to protect, we only want lawyers who are knowledgeable in New Jersey law to practice here, because otherwise the public, people retaining them may have problems because they don't know the law as well as they should. Does Florida have an interest? If you looked at this case, Florida seeks to enjoin. Enjoin means to stop this practitioner from practicing, and it goes all the way up the Florida Supreme Court. Remember, every state has its lower court, appeals court, and then Supreme Court, right? It goes up to the Florida Supreme Court. Florida Supreme Court rules against the attorney. Not surprising, right? I'm not sure if Floridian attorneys, or excuse me, judges are elected, but needless to say, they're going to try to protect the turf. Well, what does this U.S. Supreme Court say in this context?
He won the attorney.
The attorney won, right?
Yep.
And why did the U.S. attorney win? You got it. He did win, but why?
It says something about the Congress. I don't remember.
Well,
No,
the federal law, there's something called in the U.S. in the U.S. Constitution called the Supremacy Clause. And then under the U.S. Constitution, federal law reigns supreme relative to state law. It trumps, no pun intended. Federal law trumps state law, right? So.
Yeah, it says that other patents were filed by non-attorneys, so.
Well, that too. In other words, before the U.S. Patent Office, akin to filling out tax returns, you don't have to be an attorney before the U.S. Patent Office. So it just spoke about the fact that this limiting this lawyer's ability would put him at a deficit relative to people who didn't even have a law license. And on page 249, it elaborates the final full paragraph of this case that as currently, where we have a lot of states which permitted out-of-state attorneys to practice patent law, everything seemed to be fine. That the public was at no risk of being harmed. If the public was at no risk of being harmed, and if they had ruled in favor of Florida, it would have really destroyed many practices and led people to having perhaps an inability to secure good legal advice, that it was not a good idea on a practical level. Putting aside the supremacy clause from a practical perspective, it made no sense to rule in Florida's favor. So in this case, the takeaway from this, and why did the authors in a tax textbook have a case about patents? And you can take this same information and extrapolate it and apply it in the context of Title 26, meaning, hey, if someone strictly wants to practice federal tax law, no matter where they reside in the country, and they're not practicing state law, they're strictly practicing federal tax law. Well, under the Sperry case, that should work, right? Because the theory is the same, the supremacy clause. So there should be no restrictions on attorneys practicing strictly federal law.
It's similar with immigration as well.
Immigration too. It's a universal precept. All right, so this case can be extrapolated, and let's look at some of the problems here again. The timing is crucial here, so I want to get through some of these problems before our guest speaker comes. And bear in mind, our guest speaker, I may not be able to say all this, he's practiced well over 20 years. His law firm, they specialize in defense work for lawyers and accountants. That's their specialty. This is what he does 24/7. He's seen the good, the bad, the ugly of what accountants and lawyers get themselves into. He will try to not only tell you some things that he has seen, but in my opinion, pay very close attention, because he has tidbits of what you as practitioners should always be on the lookout for. So to me, at least, his information is truly invaluable. So try to absorb everything he has to say, because you're really hearing it from the horse's mouth. By the way, do you ever think about that idiom? I always think about idioms. And before the day and age of the internet, I always had to look at these up. Anyone know why people want to hear from the horse's mouth? Why? Ever think about, like, where did that come from? Never crossed your mind? You've all heard the idiom before, right?
Because I guess the person has already been through it, right?
But why a horse? Check me on this, but you would always look at a horse's mouth if you were into horse racing, because depending on their mouth, their teeth would tell you how strong the horse was. So if you heard it from the horse's mouth that it was good, horse's mouth, that was a good sign that this was gonna be a really good race. All right, so next time you hear it from the horse's mouth, you'll know, I think its origin is based on horse racing, okay? So, but I was gonna say, Lee, are you logged on? Just check, I think I've looked at that one before, but
The
origin,
tip can also tell the age.
the age, but remember, that may correlate to how fast the horse runs.
I believe you. But, it's
Yeah.
just talking about, it's not giving you the.
Not giving you the origin?
It's just saying that it's on the highest authority, but.
It's
over
not
here.
origin.
Origin, got it.
Did you,
Tips on which horses are likely winners circulate amongst punters, blah, blah, one step,
right. I mean, I think if you Google origin of horse's mouth, that you may, emphasis on the word may, come up, I recall having read that. All right, problem 5-4. Reconsider problem 5-1 and 5-2b. In the cases where you concluded that Jose or Ernesto were engaged in the practice of law, could a state succeed in unauthorized practice of law against them? Okay. Let's just,
yeah. I mean, a horse's teeth help tell you how good the horse is.
okay, so that I wasn't misleading when I said
No.
that. That's good.
You never.
Let's put it this way. I'm not sure I'm never, but sometimes I may not recollect correctly. All right. Jose or Ernesto, are they engaged in the unauthorized practice of law? Could a state succeed in an action against them?
Josie?
I'm sorry?
Josie or Jose?
Josie.
Mm-hmm.
Well, no, if Josie's doing federal income tax, say we're applying.
Right. Anytime she's doing,
I think, Professor, I think the problem that I have, like, trying to compare, right, the jurisdiction, I guess, is that normally, if an attorney from New York is representing a taxpayer in New Jersey with a federal, tax matter, usually I would assume that whatever happens federally ricochets into state, right? It flows. So how does that dynamic happen? Because most likely, is it that they just separate the two issues and, the client may say, I'm gonna hire an attorney for the federal and I'm gonna hire an attorney for the state part?
No, hold
How
on.
would that work?
Where's the controversy start?
Let's just say, violation of, 274, is that the one where you, write off expense everything?
Well, Code Section 274 deals with the limitations of Code Section 162. So Code Section 274, for example, N, limits deductions to 50%.
Similar to the case that we read where inadvertently they found out that they were in Miami, the boyfriend was.
Right, but the point is, many of these cases originate federally, and then the state will piggyback. So the point I would make is that you would hire one attorney, and then once that gets resolved, the state will pick it up. So you don't even have, you don't have to worry about the state. Meaning it will just play itself out.
So whatever it's rendered in the federal, the states have to what? They can't have their own audit and differ?
Most of the time, states are bound by the federal fine. And they're more than happy because they don't have the resources independently to review it. Now, if it's a state sales tax issue,
No.
a pizzeria is not reporting its sales tax, they're gonna send in their own auditors.
Right.
And you're not gonna have a New Jersey attorney represent someone in the New York pizza parlor. You shouldn't. So in problem 5-4, I think the author's only point here is just to say that that if you're a practitioner listed in Circular 230, right? There's only certain practitioners listed in Circular 230, right? Enrolled agents, CPAs, attorneys, actuaries. They get the protection of the supremacy clause, right? Because Circular 230 specifically protects them.
So they can practice in a different state?
They can practice federal law in whatever state they want. Federal law in whatever state they want. Because of the supremacy clause. The author's question about 5-1F, does it matter whether the advice is oral or written? No, I don't think it matters. Any advice you render, if it's not the correct advice, could be problematic. Now, 10-32, just a reminder, says nothing in the regulations in this part may be construed as authorizing persons not members of the bar to practice law. So 10.32 in Circular 230 is just an affirmation that there's nothing in Circular 230 should be construed as authorizing someone in the practice of law. All right, I'm just going to shut this for a minute. All right. So I don't think it has much import. It certainly 10.32 should not be construed as a license to practice law. There's nothing in Circular 230 that grants anyone a license to practice law. Problem 5-5 is more interesting than 5-4. 5-5. Molly is an enrolled agent who resides and has her office in Philadelphia. Can Molly represent clients whose residents, if individuals, only place of business is located across the Delaware and New Jersey before the IRS? Okay, so everyone picture, she's an enrolled agent, resides and has her office in Philadelphia. Right, so everyone has the visual. She lives across the Delaware, but she represents clients whose residence, place of business is in New Jersey. Ming, good? Thumbs up or down? It's okay. Ping, you agree? Yeah, right? Why? What's her authority?
230 is protect.
Circular 230 and spurred, right? The U.S. Supreme Court case, right? Can Molly design a pension plan for such a client? Omar A. You think so? Yes or no?
A pension plan?
Yeah.
I'll say no.
Why not?
That would be the practicing law, essentially.
What do you think, Nick?
I would say yes.
Ryan, tiebreaker.
Yes.
Why?
I'm not sure.
What does designing, the word design, that verb, seem to indicate?
Advice?
Say again?
Advice?
Advice, but
She's creating the plan and managing.
it seems to me, anytime you hear the word drafting, or I guess, to me, design means you could use the word drafting. To me, that has more, a deeper sense of a legal aroma. Like, it's one thing to do research on a tax issue. I think that's not an issue as the unauthorized practice of law. But I think you're getting yourself into much more legal territory if you're designing a pension plan. So I think this would be problematic in the unauthorized practice of law.
She could still do it if she was an enrolled retirement
That was my question.
agent, right?
Yeah.
Even then, I don't know. To me, that's more rendering it retirement advice as opposed to opining and word opining is wrong on my part. Designing a pension plan. I mean, it depends on what the word design means, but if the person is actually drafting a pension plan that has to qualify under the code, I think that's a problem. I think that really is getting into the unauthorized practice of law. So I would say, look, some of these questions, there's not definitive answers. I'm troubled by designing a pension plan. I did see, and I was thinking about you guys on the treadmill, because LegalZoom had an advertisement yesterday, and they just spoke about, have a lawyer at your disposal, and LegalZoom has some issues, right? About if they're non-lawyers telling you what to do. LegalZoom is right at the borderline of what can and can't be done.
And do you know the UPS guys, they can do the, what they say,
UPS as in United Parcel Service?
yes, they are doing, what, notary, they can
Notary.
do
Notary, that's no problem.
Oh, okay, that's no problem.
Right? That's not the practice of law. Can Molly provide client advice about tax consequences of a client's divorce? Does it matter whether or not the client is represented in the divorce proceeding by a member of the New Jersey Bar? So, in this case, Kevin, what do you think?
I think it's okay.
I mean, it's more of a state thing, so I would say it's okay.
I think it,
Tax consequences, which should
yeah, I
be
think
fine.
it depends, because it clearly says tax
Enrolled
consequences.
agents can give tax advice.
Because it would just be a simple matter of just looking at incomes and seeing what assets they have and how they normally would have reported it, and just distinguishing the difference of what it would be afterwards.
All right,
That's
so
how I'm reading it.
But they don't know the law.
the word,
But the tax consequences.
obviously, if Molly's giving advice about divorce in general, probably not a good
No,
idea,
it doesn't
right?
say that, no.
I agree. I hear you. Tax consequences, different issue. So I think you should, Kevin, be okay. But it certainly would make sense for her, Molly, to have legal counsel, right? But she may not, but that's not your issue. So this should be okay, just because the scope of services is limited to tax consequences. Can Molly do estate planning for a client? Presumably, the first part of the question is for a client who's located in New Jersey. The second part of the question is for a client whose residence is in Philadelphia, or Philadelphia. So, Viva, what do you think? Yes, no, maybe?
New Jersey, I say no. Pennsylvania, she can do it.
Peter, agree, disagree?
I don't think she can do it.
Period.
Yeah.
Why?
The estate planning, I think in itself is not what enrolled agent does.
Right, I mean,
That's not,
that's really venturing on legal advice.
that's what you do.
That's-
Right, in theory, in theory, you're supposed to bring some representation. All right, some expertise to the table. Can Molly advise such client on matters of New Jersey state law? So what do you think, Nick?
I would say yes.
Okay, why?
Actually, no, I'd switch it.
Okay, you're
Say
gonna
no.
disagree with yourself?
Because of
Why?
multi-jurisdictional.
Okay. Really shouldn't be practicing, if she's giving advice on matters pertaining to New Jersey state law, that could constitute, depending on the nature of the advice, the unauthorized practice of law, right? Could. Simple research, probably not an issue, but if she starts writing opinion letters and things like that, that's gonna be a problem, right?
So advice also she cannot give it. Advice also she's not.
I mean, again, I think she can, she's an enrolled agent, if the person has simple tax questions and does a little research, that's fine, but if she's under audit from New Jersey and she has to write paperwork up, it really should probably be handled by a New Jersey tax
No,
attorney.
what? An enrolled agent can represent in audits.
But again, when it deals with state law, you could border on unauthorized practice of law, right?
She's a legal, she goes back to the
Again, states are probably not gonna aggressively go after her, but she runs a greater risk that if she does something wrong, she may have some malpractice issues. Can Molly represent such a client in a Jersey state tax audit? And if you want a distinction, no pun intended, 5 little I versus 6 little I. 5 little I, maybe she'd be okay, right? General tax advice. But 6 little I, Molly's gonna have much more of a problem because probably should not be representing someone on a state law legal dispute. And she can't invoke the Sperry decision, right? The US Supreme Court decision, which the supremacy clause doesn't apply with respect to New Jersey law, right? Same facts as A above, except that Molly's admitted to Pennsylvania, but not to the New Jersey part. So she's a Pennsylvania attorney. This deals with multi-jurisdictional practice. Can she do all the above, or are there any restrictions? She probably can do all the above with the caveat, keep in mind, that she probably, as a Pennsylvania attorney, when it comes to items 4 little I, 5 little I, and 6 little I, all pertaining to New Jersey, if she's only licensed in Pennsylvania, probably should not be rendering advice on New Jersey law. By the way, I'm just checking my cell phone to make sure that that Tim did not text me. It was not Tim. Okay. Same facts as B above. So for your notes, the only responses to question B is Molly should not undertake obligations specified in 4 little I, 5 little I, and 6 little I. Question C. Same facts as B above, except that Molly's membership in the Pennsylvania bar has been suspended. So if her membership in the bar has been suspended,
She's doing it anywhere.
she really shouldn't be practicing anything that has the aroma of being law related. So I think this takes her out. And in question D, it says same facts as C, except that Molly is also a CPA in good standing in Pennsylvania. In other words, for some reason her bar license has been suspended, but her CPA license is not. And do you think the bar would look fondly upon this if you've been suspended and saying through the back door, oh, but I have my CPA license, so when I'm doing this, I'm doing it as a CPA and not a lawyer? I think you're running the risk that you're violating the terms and conditions of your suspension. All right, obviously that's going to vary from state to state. If you decided to, pursue this path, I would certainly, if I was the advising this person, I would check with the Bar Association, get permission, and say you intend to do A, B, and C under your CPA license. My guess is the first thing the Bar Association would do is contact the CPA Association and say, hey, do you know that we suspended this person because of reasons A, B, and C? Chances are you would have your CPA license suspended as well. So I think you're not going to be able to practice in either event. In question E and F, same facts as A, except that the question is whether Molly can provide federal tax advice about a planned merger of a New Jersey corporation into a Pennsylvania corporation. The merger will be governed by Pennsylvania law. Now, mergers, by the way, generally, are they dictated by federal or state law?
say state?
Generally, they're state, you file the documents with the Secretary of State of New Jersey or Pennsylvania, wherever the merger is gonna happen. But remember, can she provide federal tax advice? That's under Code Section 368, tax-free reorgs. Can she render federal advice, guys? Your answer is, Ming, you're shaking north to south, yes?
Yes.
Okay, why?
Federal issue.
That's under the
We just-
Sperry case, right? The supremacy clause. And Circular 230 allows enrolled agents to offer or opine on federal law issues, right?
Do you draft margin also from the lawyer? We have, if we have to read it.
Well, if I'm a Pennsylvania lawyer, and it's gonna be governed by Pennsylvania law, I'm okay with it if I'm a lawyer. Question F, if the merger is gonna be governed by New Jersey law, but I'm only licensed in Pennsylvania, I think that you have some issues and that you should consider on this person prophylactically contacting a Pennsylvania attorney and just making sure that there's nothing unusual or unique. Needless to say, best practices, guys, if this issue came up in your office and you're the accountant on this, if in question F, I would say to the attorney that you're working with, hey, you should reach out to the client and get their permission to reach out to local counsel in New Jersey, just to make sure this is all copacetic. The more you can tell your client, the better, in my opinion, because informed clients, or again, my opinion, you can talk to the expert when he arrives, are less apt to sue you. Where clients feel that for whatever reason you weren't kept in the loop, that's when you might have issues come up, right? Problem 5-6, Manuel is a CPA licensed to practice in Virginia. And by the way, I know many of you are thinking, most of you, many of you are CPAs, and you're thinking to yourself, gee, lawyers get stuck, they have limitations on where they can practice, right? And that's gonna be explored more in the next section. Because some of you, many of you, your firms have clients sprinkled throughout the country, right? Some of you? Eva, you have clients where?
New York was, in US we have New York, Minnesota, then Delaware.
Minnesota, Delaware, all those places,
Yes,
right?
yes.
Anyone else have California places? Minnesota, you're saying yes, Nick?
Yeah,
Right. The only, and it's great to have these clients, right, Nick?
Mhm.
Right, Viva?
Yes.
sometimes.
Right? Sometimes, I mean, because sometimes you might have to, California doesn't sound bad on a day like today, but Minnesota does, all right? And why am I saying that? Because again, if there's a problem and you make a mistake, they have jurisdiction in Minnesota. So you might find yourself having to fly out to Minnesota for depositions and court dates and things like that. So it's great to have these clients in these hopefully nice states, and periodically visiting them. But the downside is if something goes awry, you've accepted responsibility to.
They first live in New Jersey, then they move to the Minnesota, so like they know whatever the work going on from New Jersey to them.
Yeah. Okay, but you know that they're in Minnesota is the bottom line. All right. So he's licensed to practice in Virginia. He's also been admitted to the bar in the United States Tax Court. Manuel has represented a Virginia client on a particular tax matter before the IRS through both the audit and administrative appeals process. A notice of deficiency is issued, and he recommended the client file a petition in the tax court. Is your answer different as Manuel is instead of being a member of the bar in North Carolina, is a member of the bar of North Carolina, but not Virginia. What did the author's point here?
He can do it, right?
Yeah, it's the same.
Yeah.
It's federal, so we can go
Yeah, he can do it.
very and section 230 parcel.
He can. Just keep in mind, what do we know? Some of you had your first class in federal tax procedure. I don't know if they. What courts do you bring your case in, just to remind people if there's a tax controversy? Tax court or Wells? Do you guys remember from? I don't know if they raised, if you raised this during the first class. Todd? Guys, remember what are the courts that you can bring your case in? District court, tax court, and the court of claims, right? 3 different jurisdictions. And why choose one versus the other, guys? Do you remember? What is the difference?
Some are state and some are federal.
Say again?
Some are state and
No,
some
no,
are
these are
federal.
all 3 federal.
Where are they again?
District court, tax court, court of claims.
Depends on what.
Say again, Nick?
Is there a jury on district?
In district court, you get a jury. What about the tax court? Tax court is the only one where you don't have to pay in advance. Where with the district court and court of claims, you have to pay and then sue for a refund. So most taxpayers prefer the tax court. Obviously in tax court, you get the expertise of a judge who specializes in tax. In district court, court of claims, you don't. There may be, emphasis on the word may, be more, how do I say, favorable authority. Remember, you appeal to different circuit courts, and the Court of Claims appeals to the Federal Circuit Court in DC. So there may be more favorable precedent in one venue versus another. So I think he can practice and do this and not have an issue wherever he is. Again, under Spurry, that he doesn't have to worry about this. I am going to distribute to you, by the way, multi-jurisdictional practice. Some of you, many of you, probably already have this, but just to make life easy for people, this is Rule 5.5. This is so, Rule 5.5, a lawyer shall not practice law in a jurisdiction in violation of the regulation of the legal profession in that jurisdiction or assist another in doing so. So generally, you're not supposed to practice outside the state you're licensed to practice. And there are exceptions, but let's talk about, if my pronunciation is not off, Verbrauer. This is on page 251. You guys have a chance to read this? Anyone found this case interesting? The lawyers here being a little bit too, how do I say, flippant with the.
The main issue is that this firm, which is New York based, and they represent one of the client to the California.
Okay, so we have a New York firm, parentheses, do I know this for sure? Perhaps acting a little bit arrogant because they have the New York swagger, because they can do better than anyone else, and they're gonna take on the opposition, and their client is in California, the opposition's in California, so they're gonna march out to California, right? Not a bad thing to do. Have some cold winters, I think we can all say that, and I presume California is a nice, well, most of you have been to California, know most of California is very nice to be. Page 252, the first full paragraph. The name of the client is ESQ. Talks about, well, that first paragraph talks about the nature of the client. Being a California client, they're suing Tandem. The next paragraph on page 252 explains that there's going to be a lot of activity in California, right? This is not something where they're calling their clients in California and maybe taking one plane flight out there. There's just lots and lots of activities going on there, right? And they enter into, in the last full paragraph, they enter into a fee agreement with the client, the law firm, that they're going to pay Bergbauer over $1 million. It's the legal fee. But subsequently, the client sues the law firm for legal malpractice and does it, surprise, surprise, in Santa Clara County Superior Court. And the law firm moves for the matter to be heard in federal court and wants to get paid. And no one's going to fall off their chair when you learn, how does California, the lower court rule? This is they're going to prick. I'm going to sound cynical here, but the judges are going to protect their brethren attorneys. You got this New York firm, East Coast, West Coast, a little competition between the coasts. And they're going to rule against the New York law firm, that the lower court, the Court of Appeals, hears this because there's this section 6125 in California. It's not that important for our purpose, but there's an actual statute in California that says essentially no person shall practice law who's not licensed in the state. Not surprisingly, I'm sure most states have something equivalent. And the question is, what this law firm did it constitute the practice of law in California? What does the word practice? So this court has to explore what is the practice of law in a different state. Now, by the way, many times lawyers from, for example, New York, sometimes argue cases in New Jersey or vice versa, or New York attorneys do argue cases periodically in California. There's something called, and you'll see this mentioned on page 255, the first, second, third paragraph down, the second line down, towards the very end of that second line, pro hockey vici, if I pronounce that correctly, pro hockey vici, I think is the pronunciation. This is the third full paragraph down, second line towards the right hand side, pro hoc vici. You see that? See? This is on page 255.
Oh.
Third paragraph. Pro hockey vici. It gives you permission to argue a case in a foreign jurisdiction. But it's a very limited exception. Generally, you're not supposed to practice law in another state. And on page 256, at the very top, this court elaborates that these attorneys were spending a lot of time in California. And law firm made, on the first paragraph on page 256, makes some sort of lame argument that this section 6125 is only supposed to apply to non-attorneys. It sort of says that non-attorneys should not practice law. But no, that's not what 6125 really meant. It just meant that you're not supposed to practice law in California unless you're licensed in the state. So the court goes through here and says, look, you were doing, right, Viva? You were doing a lot of activities here in California. You're not licensed to practice here. So,
Can they do that you should be California citizen?
well, you know, in some respects, by the way, I think the unfortunate part here is the client here, just like in a Garian case, the case we looked at the end of the last class, where the accountant got a great result and the client refused to pay. And what is the whole purpose of these rules? Is to protect the public. At least based on my reading this case, here the law firm got a good result for the client, okay? At least that was my takeaway. Did the client really need protection here? I don't think so. But the California court found it hard to just say, hey, we want all these New York firms invading on our turf. This was a bit too much. You wanted, what was the easy solution for the New York firm? What should the New York firm have done that would have saved it all this anguish? Simple thing. What should the New York firm have done to put this whole thing could have got before, not after the fact, before? What should the New York firm have done to make this whole thing?
Hire
a
California attorney.
Yeah, said to the California client, listen, just do us a favor. Retain a California firm that we're going to work with. We're going to do 90% of the work, maybe 95% of the work. But we got to, you're in California, opposing parties in California. We're not in California. So just to give it the imprimatur that we're doing everything by the books, just let's retain California counsel. We'll work hand in hand. It's not going to cause you to be double billed. All those things. Would this case be here today? I don't think so. But their arrogance got in the way.
You know, do that way. They can they can hire attorney over there, and both companies can be the practice together that way.
I don't know what you mean. They can.
Suppose I can. I don't want to open a firm over there, but I can hire an attorney over there, and he can do behalf of my.
Right. You don't have to open up a firm.
Yes.
You don't have to hire employees in California. All you have to do is retain local California counsel, separate law firm.
Yes.
Nothing to do with you. That's all you have to do. All right, so this could have been easily resolved. Instead, apparently, they're only going to get paid for whatever work they did in New York. The work they did in California, they're not going to be paid on. You know, there's a dissenting opinion that really says that the practice of law should be limited to where you're actually appearing before a court. I mean, look, these New York lawyers who did what they did, they were just negotiating. It wasn't, like, to me, this was not egregious where they were heavily into California law per se, but they had a very, they were very immersed physically in California, so they sort of invited this problem upon themselves. The dissent is you know, it's a meaningful dissent because, again, the practice of law is hard to exactly put your finger on it, and where the public really needs protected, I think, is really in court proceedings. Like, lawyers should be trained to handle these kind of negotiations no matter where they happen, Alabama, California, New York. This was just a negotiating to settle a deal. You didn't need any special expertise, but if this had gone up to a California court system, which it hadn't, then they should not have been in the California courts. But a dissent is just that is not the controlling law. So your takeaway here is if you're too aggressive and you're working with a law firm that's too aggressive, and you're the accountants, and you're tied up with that aggressive law firm that's not getting co-counsel in California, you may have problems when fees are sought to be collected. Right? Now, what's the cliche? An ounce of prevention,
It's worth a pound of cure.
worth a pound of cure, right? All right, so we all know what should have been done here. By the way, did anyone reminisce about the Super Bowl of last year and your favorite commercial from last year and anything that you expect to see this year? Someone brought it up, so I had to go on YouTube today. If you guys, there's a Sprint commercial with a bunch of robots, if you remember from last year's Super Bowl. And the robots keep yelling at the programmer and essentially say, "You idiot, why aren't you switching over from Sprint? You're paying 4 times more for Verizon." And when he comes to the Sprint store, they said, "Sir, what brings you here today?" And he said, "Oh, my coworkers insisted I come." It was a kind of funny take if you haven't seen the commercial. Anyone have a favorite they want to share? Anyone remember? See, people spend millions and millions to produce these commercials, and the fact you don't remember is not a good sign, right?
Budweiser's always a good one.
What was that thing?
Budweiser.
Budweiser, if you like horses, right? The Clydesdales come.
The dog and the whole.
Right.
Yeah, so
They're often very touching. But some of them, I imagine that many of you have sat through, and you're like, this was what the best and the brightest could come up with in terms of a commercial. So.
sometimes it's really stupid. You
Yeah.
think it's really stupid.
Yeah, I mean, some are very creative, many I wonder. All right, so on page 263, the authors point out that Burbrower's quote-unquote stunned the legal community. This is right after the opinion, because a lot of people probably got unnerved by this. The next paragraph says the response to Burbrower was swift. The California legislature enacted temporary rule authorizing out-of-state lawyers to represent clients in California arbitrations. So it liberalized the law, recognizing that you do need to have sometimes people from outside of California, lawyers outside of California can participate in certain activities. Spelled out also on page 264, Rule 9.48 permits non-litigating attorneys, non-litigating, or temporarily in California to provide legal service to California clients. Providing legal service or advice in California on an issue of federal law, right? Not surprising. Providing legal service or advice in California to a client considering a transaction or other non-litigating, emphasis on non-litigating, all sorts of little things like that. So there are exceptions, right? This is not a hard and fast rule. California want to make sure that it didn't create too many impediments for out-of-state attorneys. So again, simple solution here. We had this case that follows soon after on the heels of Burbrower, right? So Burbrower, just to get our bearings, is also a 1998 case. I have a suspicion that this case was rendered after Burbrower. I know it was because it makes reference to Burbrower. So Burbrower probably came out early in 1998. This case comes out later in 1998. All right, so this is the estate of Condon. I did a little graphic, not the prettiest, of what happened here. Anyone enticed by family dynamics and bloodbath between siblings? So, if you guys recall, we had mom at the top, and she used the Elrod firm. She dies. Yeah. Yeah, she had 2 children, right?
Yeah.
And she had Michael,
Yeah.
MC, Michael, and
The other one is.
Carolyn, I think was her name?
No.
Yeah, Carolyn M. Henry, right?
Yeah,
And
Wicked
this is-
Henry.
Right. And she's from California.
California, and she lives with her mother.
He's from Colorado.
Mm-hmm.
And he retains Elrod,
See.
right? Because Elrod drew up the documents. She retains a California law firm, Carr firm. And Cody is the name of the attorney. And Elrod is smart. Why is Elrod smart, the law firm? And Katz is the name. Katz is the name of the attorney here.
He's not a member of California Bar.
He's not, but he's smart enough to,
Give it to
he gets local counsel.
Yes.
Mm.
He gets, it's called the Evans firm.
That case was interesting.
And local counsel's name, I think, is Campisi. Campisi. Is this a small or large matter for the Elrod firm? Was this a 5-minute probate estate matter? If you look at the first footnote, guys, footnote 12, there was a buy-sell agreement. There's a whole bunch of things going on. This was not a 5-minute job. To the contrary, do the arithmetic here. There were 315 billable hours. That's a lot of billable hours, if you don't mind me saying so. That's someone working, you know, pretty much full-time, perhaps, on this for a few months. Apparently, this brother and sister hated each other, and there was a lot of disputes over the estate. Obviously, Elrod would like to get paid, but the sister says their fees are unreasonable, and says essentially that this firm, Elrod, was doing too much work in California, just like Burbauer, right? It should not be paid, right?
With the difference that they got the attorney.
Well, at least at the trial court level, this is in the second paragraph on page 265. It says the probate judge never reached the issues Caroline raised. Once he determined that Katz was not a member of the California bar and not applied to appear, here's our favorite term, pro hoc vici, he expressed his view that Katz was not, quote unquote, an attorney within the meaning of the probate code. Okay? So, and he said, I will give you 2 hours to come up with some authority for me to order payment out of a California estate to a member, a non-member of the California bar for attorney's fees. And then, obviously, 2 hours is not going to be enough time to write a compelling argument. So, he loses. And then if you read the next paragraph, they decide they're going to grant full review, and they deferred resolution of this case till the Supreme Court resolved the Burbauer matter, right? Everyone see that? So once the matter, now you might think Burbauer was going to make this case a slam dunk in favor of the sister, right? Because now Burbauer essentially said, well, you shouldn't have out-of-state attorneys practicing. So I'm sure once Burbauer was rendered, they opened some champagne bottles. When I say they, Carolyn, attorney, said, we're going to win this. And the question is, does it? And the court, if you can hear to my voice, does reach the opposite conclusion. The court does say this was permissible. Right? This was permissible.
If I'm not mistaken, it was because the brother who had hired them or was helping them was from Colorado.
Well,
and that's where they did most of the work.
Well, the client here, who's the client?
The dead mom.
Well, she's dead. So
yeah, so it will be the brother.
Well, the brother, right, is from Colorado, so the client is truly a Colorado client, which is in Burbauer, right, and Kevin's raising a salient distinction because California was trying to protect the client in that case who was in California. And here, hey, this client, where does the brother reside? He resides in Colorado. Do you really want to force people? I mean, it would be rude and obnoxious and not good to have to retain counsel in California. Do you live in Colorado? So that's an important distinction. And that's pointed out to Kevin's point on 267, right under item 3, that the client here is truly in Colorado. And then by way of contrast too, the paragraph that immediately follows, much of the legal work was actually performed in Colorado, correct? And not surprisingly, here the brother does prevail and the law firm is entitled to fair compensation. So, on page 269, there's a discussion of, and you guys have the model rule 5.5, talks about 5.5a makes it a violation of a state's rules of licensure to practice in another jurisdiction and violence. So if you are in New York, if you're a New York attorney and you're practicing in California, the New York bar is the one who's supposed to punish you if you're not California per se. New York is supposed to be the one to which you're supposed to, because New York is the one who licenses you, so New York is the one who should censor you or suspend your license. I think I see Tim here. You do. You do. See, we had a little trick there. So why don't we do this, because I'm so happy he's here. And I want to make sure that we give him the maximum time. So, guys, we could take a 4-minute bathroom break if anyone needs to stop, and then we will get going in 4 minutes, and Tim will give us all of his wisdom, or as much as possible in the time he can give us. So, 4 minutes. Come on back.
Take about 2 seconds.
Maybe a 5-minute lecture here. Hey, how are you?
Man, it's cold.